Hey guys, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. We have a ruling in Blake Lively's complaint against Jed Wallace. Now, this is in the New York court, so this is not pertaining to his lawsuit in Texas. That is the motion to dismiss filed by Blake in that court has not yet been ruled on. So this was just pertaining to his complaint in New York. Remember that when she first filed her complaint, she did not name him in her lawsuit. He then sued her in Texas, but then she came back in her amended complaint and named him. So they were kind of arguing over where this belongs. But we're going to get into it. I just want to say really quickly, guys, I saw some confusion about this subpoena thing in regards to subscriber information because I saw a lot of people were really concerned about people who are subscribed to these channels having their information given if, they were successful in getting the information they had sent the subpoena for. So that information is my information as the subscriber, which is what they would be seeking. I don't believe that. YouTube wouldn't even have all that information for subscribers to my channel. It would be my information. So I do have to talk to the lawyers, her lawyers, so I'll clear that up. But other than that, I'm going to kind of put a stop on talking too much about that while this is ongoing. So I saw someone ask, does this mean, those subpoenas are not going to be in place anymore? I don't think so. I think that's still a problem. So we're going to have to work on that. So anyways, let's just talk about this. I just wanted to ease some people's minds with that because I know that was freaking some people out. All right. I skimmed over the background and everything because I only have a quick break from work. So we're going to skip right to the discussion on this. Lively's amended complaint alleges 4 claims against the Wallace defendants. 1, aiding and abetting retaliation in violation of the California FEHA. Intentional infliction of emotional distress. Didn't she drop that one, right? Yeah. Huh. Okay. 3, false light invasion of privacy, and 4, civil conspiracy. Right. The Wallace defendants first argue that the claims against them should be dismissed for lack of personal jurisdiction. They then argue that in the alternative, venue is improper and the case should be transferred to the Western District of Texas, where his lawsuit is ongoing. Finally, they argue that the allegations against Wallace fail to state a claim. The Wallace defendants' motion to dismiss must be granted because the court lacks personal jurisdiction over them. Personal jurisdiction is claim-specific and defendant-specific. It ensures that there is a connection between each defendant being sued and the place the defendant is being sued, so that a defendant is not forced to litigate in an unexpected and faraway forum. Lively's case against the other defendants will proceed in this court, but the Wallace defendants are located in Texas, and Lively has not alleged that they are responsible for any act that would subject them to jurisdiction in New York. The alleged negative publicity campaign against Lively largely took place outside of New York. The few alleged actions targeting New York were taken by others. Yeah. And there are no allegations suggesting the Wallace defendants were aware of them. So this guy was saying in his affidavit, I've never met this lady. I was never on the set of the film. He's never even met Justin Baldoni. All right. Therefore, the Wallace defendants cannot be forced to defend this lawsuit in New York. If Lively wishes to pursue her claims against the Wallace defendants, she must do so in another forum or replead her complaint to allege jurisdiction over the Wallace defendants in this forum. Okay. I'm going to skim over that. Because the motion to dismiss must be granted for lack of personal jurisdiction, the court need not consider the Wallace defendants' additional arguments. All right. So they're just going to talk a lot about that here. I'm not going to read too much through it. I think, like I said, I only have a quick break to work. I'll post a link to the full ruling that you can go over if you want. On a Rule 12b-2 motion to dismiss for lack of personal jurisdiction, the plaintiff bears the burden of showing that the court has jurisdiction over the defendant. Where discovery has not been conducted, the plaintiff need only make and I fucking hate that word because I pronounce it wrong every time. I think it's like prima facie or something. Showing of jurisdiction, which may be established solely by allegations. However, the plaintiff must provide factual specificity rather than relying on conclusory statements. All right. Give me one sec here. She doesn't want to come to Texas. Man, I keep getting stuck in Texas, but I never get to do anything fun because it's always when I'm flying through Houston. I hate it. All right. Jed should not give up his client list. Well, I don't know if he has to, no? Not sure. I don't think so. The parties dispute whether the court may properly consider at this stage the declaration submitted by Wallace, which states, among other things, that he was not part of any conspiracy against Lively and only participated in passive analysis of the media environment, which he understood to be for clients in California. Okay. The court may consider affidavits and other materials beyond the pleadings when assessing a motion to dismiss for lack of personal jurisdiction. However, the Second Circuit has clarified that a court may not discount a plaintiff's allegations in favor of affidavits submitted by defendants without holding an evidentiary hearing or permitting jurisdictional discovery. All right. Therefore, while the court may consider Wallace's declaration, it may not credit it over conflicting allegations in the pleadings without holding an evidentiary hearing or ordering jurisdictional discovery. There is no need for such procedures here because, as discussed below, even assuming the truth of the allegations in Lively's amended complaint, they do not establish personal jurisdiction over the Wallace defendants. The court must conduct a two-part inquiry to determine personal jurisdiction over a non-domiciliary. Okay. I'm not going to lie, guys. Like I said, I had to get back to work, so I'm not going to read too much about the state law and all that. I'll post the link for you, though. Plaintiff does not argue that the Wallace defendants themselves had contact with New York that would satisfy CPLR 301 or 302. Nor could she. The Wallace defendants are not subject to general jurisdiction in New York. Wallace resides in Texas, and Street Relations is incorporated in California with its principal place of business in Texas. There also are no factual allegations that either of the Wallace defendants has transacted any business in New York or committed tortious acts within New York so as to establish specific jurisdiction based on the conduct of the Wallace defendants in isolation. The amended complaint does allege that the Wallace defendants' tortious acts caused injury to Lively in New York. However, CPLR 302A3 additionally requires a showing that the defendant either regularly does or solicits business in the state or expects or should reasonably expect the act to have consequences in the state and derive substantial revenue from interstate or international commerce. Plaintiff has not alleged any facts regarding the Wallace defendants' general course of business or revenue. One sec. Plaintiff founds jurisdiction instead on a conspiracy-based theory of jurisdiction, pursuant to which other co-conspirators' actions in New York would be imputed to Wallace defendants. Conspiracy jurisdiction is based on the time-honored notion that the acts of a conspirator in furtherance of a conspiracy may be attributed to the other members of a conspiracy. The theory posits that one conspirator's minimum contacts allow for personal jurisdiction over a co-conspirator even when the co-conspirator lacks such contacts itself. Plaintiff argues that such a theory supports jurisdiction under either, and then, CPL or whatever. The argument is that tortious acts taken by co-conspirators within New York should subject the Wallace defendants to personal jurisdiction in New York. Okay. The argument is that the conduct of some co-conspirators in sending communications in New York, and I think that was Melissa Nathan, or transacting business here from outside the state should subject the Wallace defendants to personal jurisdiction in New York. The former theory is well recognized, while the latter would be an extension of existing law. The court therefore turns first to jurisdiction under CPLR 302A2. Like I said, I don't want to read too much into this. To establish personal jurisdiction over a co-conspirator under an agency theory of jurisdiction, a plaintiff must allege first that the defendant was part of a conspiracy involving overt acts in New York, and second, that the defendant had an awareness of the effects in New York of its activity. The activity of the co-conspirators in New York was to benefit the out-of-state conspirators. Okay. Well, that wouldn't make sense. So, the co-conspirators acting in New York acted at the direction or under the control or at the request of or on behalf of the out-of-state defendant. Okay. Yeah, we're gonna skim over this because I gotta get back to work, like I said, in about 5-10 minutes. The Second Circuit has held that the third requirement that the New York-based co-conspirators acted at the direction or under the control of the out-of-state defendant may be satisfied by an allegation that the out-of-state defendant will. So even though he had not been on the set of the film or anything like that, he would have been, I guess the theory there was he would have been aware of it. This holding is based on the First Department's decision, and it's something I'm not going to read right now because I don't have time. The Wallace defendants argue that this understanding is not consistent with more recent New York cases, requiring that the out-of-state defendant have some extent of control over the in-state actor in order for contacts to be imputed. This argument has some force. The concept of conspiracy jurisdiction derives from something else I'm not going to read right now because I don't have time. I'm really sorry about this, guys. You know, I would love to sit here and read every word of this, but I'm going to have to do it later. Let me just come down here. All right. Plaintiff's claim fails at the threshold, however, because she has not alleged that any co-conspirator performed overt acts in furtherance of the conspiracy while that co-conspirator was physically present in New York. The amended complaint alleges a number of actions and communications that form the conspiracy to damage Lively's reputation, but not that any of them took place in New York. The alleged co-conspirators mainly reside and do business in California. All right. I keep checking back to make sure I haven't muted myself because Omar has like spooked me into it. Give me 1 second. Lively alleges that certain co-conspirators took actions within New York during the filming of It Ends With Us. Yep. Noting that Baldoni and Heath's meeting in New York with Lively to discuss harassment and misconduct. Yeah, okay. But these actions were not within the scope of or in furtherance of the alleged conspiracy to retaliate against Lively, which did not begin until after filming ended. Okay. This plan took shape with Wayfarer's retention on behalf of Wayfarer and Mr. Baldoni of Miss Nathan, which occurred on or around July 31st. The amended complaint alleges that Nathan lived in Brooklyn, New York during a portion of the relevant period, but it does not specify the relevant period or, more importantly, any actions Nathan took in New York in furtherance of the conspiracy. The fact that Nathan lived in New York at some unspecified time over the course of the conspiracy does not itself give rise to inference that she took an action in furtherance of the conspiracy while in New York, particularly when she also resided in California and was working with others who lived in California and Texas. Okay. Finally, the amended complaint alleges that Sarowitz threatened... Oh, God, this again. Okay. Well, I know he has to, like, rehash it, but still, I hate this part. That Sarowitz threatened to ruin the lives of Miss Lively and her family while attending the film's New York premiere. Specifically, he stated to a witness at that event that he was prepared to spend $100 million to ruin the lives of Miss Lively and her family. However, Lively has not alleged facts showing that this was an overt act performed by any conspirator for the purpose of accomplishing the objectives of the conspiracy. Well, yeah. Also, that's not like something that was recorded or anything like that. I think that's just she's saying that's what he said to someone else. You know what I mean? A conversation may constitute an overt act in furtherance of a conspiracy, but only if it tends to carry out the object of the conspiracy. Here, there's nothing to suggest an inference that Sarowitz was attempting to recruit a co-conspirator, trying to cause Lively distress, or taking any other action in furtherance of the conspiracy. He simply stated to an unidentified witness that he was prepared to spend money to harm Lively. The statement describes the existence of the conspiracy, but there is no basis to infer it was intended to advance the conspiracy. Moreover, assuming that Nathan or Sarowitz took actions in New York in furtherance of the conspiracy, Lively has not shown that such acts may be imputed to the Wallace defendants for jurisdictional purposes. Such imputation requires a showing that the Wallace defendants were aware of the torts being committed by co-conspirators in New York. There are no allegations indicating the Wallace defendants were aware that Nathan was residing in New York or taking any actions there. Wallace declares that he believed Nathan was in California. The Wallace defendants are not alleged to have been in close contact with Sarowitz, and there's no reason to infer they would be aware of statements he made when they were not present and several days before they were allegedly hired. And again, a lot of this started before he was even brought on board, even the negative press around her, apparently. So I remember they were arguing that a lot. Even cases which have not required a showing of control over the co-conspirator have made it clear that awareness is required. Okay. Lively also argues that the co-conspirators had extensive suit-related A1 contacts with New York that must be attributed to the Wallace defendants. The Wallace defendants argue this theory is without precedent and inapplicable. Okay. I'm skimming over some more of this stuff, guys. Assuming without deciding that a defendant can be hailed. Is that how you say that? It's not spelled right. No, I just don't know that word. Into a New York court based on conduct by a co-conspirator outside the state that would give rise to 302A1 personal jurisdiction. Lively has not alleged any such conduct by a co-conspirator of which the Wallace defendants had knowledge. Lively alleges that as part of their efforts to bury Lively, Nathan, Abel, Wallace, and Street relations targeted New York by, among other things, communicating with or causing content to be provided to journalists, content creators, and media entities based in New York, including at least one journalist at the New York Post and another at the New York Times. I think one was Melissa Nathan's sister. Sarah, yeah, right there. Sarah. Let me see this. What is this? No, we're not going to read that. This is supported by specific allegations that Abel and Nathan communicated with Nathan's sister, Sarah Nathan, a journalist at the New York Post and Page 6, on multiple occasions to shape coverage and contribute to stories that were eventually published in those outlets. These allegations might support personal jurisdiction against Abel and Nathan, even if those two did not engage in their conduct from within New York. Okay. However, Lively has not alleged facts that would show that the Wallace defendants were aware of those jurisdictional contacts. Okay. The amended complaint alleges that Wallace was generally in contact with Abel, Nathan, and Tag is Melissa Nathan's PR agency, and that they worked together to suppress negative content about Baldoni and amplify negative content about Lively. It is fair to infer that Wallace would have known as a general matter that Abel and Nathan were talking to media outlets in furtherance of this aim. However, there are crucially no allegations that Wallace was aware of Nathan and Abel's contacts with Sarah Nathan or any other actions targeted at New York. Therefore, even if imputation of contacts on a theory of conspiracy could theoretically satisfy CPLR, no such imputation can occur here. For similar reasons, the exercise of personal jurisdiction here would not satisfy due process. Okay. As stated above, the amended complaint contains no factual allegations that the Wallace defendants directed or controlled any conduct in New York or were aware of any actions taken in New York or directed at New York. This lack of control or awareness is fatal under the Due Process Clause, just as it is under the CPLR. Okay. Lively argues that if there is any doubt as to personal jurisdiction over the Wallace parties, the court should order jurisdictional discovery. Jurisdictional discovery is warranted where, even if a plaintiff has not made a prima facie showing, I don't even know how to pronounce that still, she has made a sufficient start, what did I just say, towards establishing personal jurisdiction. However, a district court retains considerable latitude in devising the procedures it will follow to ferret out the facts pertinent to jurisdiction. Here, jurisdictional discovery is not necessary or appropriate, given that Lively has not alleged any action by anyone in the conspiracy within New York or any contacts with New York whatsoever that the Wallace defendants were aware of. She has not made a sufficient start towards establishing personal jurisdiction. Moreover, if relevant jurisdictional contacts occurred, and Wallace was aware of them, this information is connected to the merits of Lively's claims and would logically be revealed by ongoing document discovery from Wallace and his co-conspirators, not separate jurisdictional discovery from Wallace. The substantial completion deadline for such discovery has already passed. In recognition of the possibility that jurisdictionally relevant facts may be revealed or already have been revealed in discovery, Lively shall have leave to amend her complaint by July 30th, 2025, limited to the existing claims alleged against the Wallace defendants. Okay. So if she wants to do that by July 30th, she can. That's 2 weeks from now. The motion to dismiss is granted without prejudice. Got it. All right. Well, thanks, guys. Like I said, sorry I couldn't go through the whole thing. I just wanted to do that really quickly and now I have to get back to work. But did you guys hear they want subscriber info? I'm the subscriber. They want my info. Don't worry about that, dude. Don't worry about that. If somehow I'm incorrect on that, I will let you know. But you don't need to worry about that. They're asking for my stuff, not my channel subscribers stuff. Me, the subscriber. So you're good. All right. Crafted Moments, thank you for the 5. We are with you, Lauren. Good luck with your motion to quash. Thank you very much. I have a lot of work to do. Nicole, thank you for the 10. I'm new and I love your show. Well, thank you very much. I appreciate you being here. Sorry, this was not my best, but it is early still, and also, like I said, I gotta get back to work. So, I was actually supposed to be filming with Andy this morning, but then we had to reschedule that. So I will be doing that sometime tomorrow, I think. We'll see. All right. Thank you, everybody. I'm going to be back with you later today or tomorrow. We'll see. Like I said, I got a lot of work to do. So, and I've only been home for a minute. So, see you later.